Well, I guess we're on the record, so, but we're not live streaming yet. Okay, we are finally ready to go on Stinson versus Stinson. Counsel, state your appearances, please.
Attorney Janet Hamilton on behalf of the plaintiff, Christy Ann Stinson, Your Honor.
Good morning, Your Honor. Attorney Jennifer Payne from Pinnacle Family Law, appearing by Zoom on behalf of Jacob Stinson. He's at work today, so he's not participating.
All right, and Shannon, Ms. Stinson is present in the Zoom room. Okay, let's see. We're here on objections to a child support recommended order, is that correct?
Yes, Your Honor.
And Ms. Hamilton, these are your client's objections.
That is correct.
Go ahead.
Have you had an opportunity to read them, Your Honor? I don't want to fill up your docket with.
I looked at them yesterday, yes.
It does appear that there are several $1,000s in non-taxable additional components of the defendant's income that for whatever reason don't appear to have been disclosed by him to the front of the court when the child support investigation was done. I will note to the court that we had a little bit of a special judgment in this case. It was entered by consent, and we agreed that Mr. Stinson was going to pay unallocated family support at a particular rate through October of 2019. And it then expired by its own terms, and this investigation was commenced on the initiative of plaintiff, but because Mr. Stinson's income is significantly understated, the calculations are off. And sadly, Ms. Stinson, who is living like on a deficiency budget, has received no child support from Mr. Stinson since October of 2019. The components of...
Why is that?
Because because it took that long for the friend of the court to do their investigation when she initiated the new support. Remember, unallocated family support stopped by the terms of the judgment in October of 2019. And at that point, child support was supposed to kick in.
But it didn't.
But it didn't until
I
the
got you.
investigation took
So
a long time.
it wasn't just a matter of omitting the non-taxable portion. She wasn't getting any support at all.
Correct.
Okay, I'm with you.
No, just to be clear, in fairness, I suppose Mr. Stinson could take the position that he wasn't obligated by any court order after October of 2019. So we're not suggesting that he should be held in contempt for that, but he has professed to want to have custody of this child and be an active parent. We would think that he would contribute something to the child support during this time. Direct credits can be issued, but we've received nothing. So this is what we're asking you to do today, Your Honor. The actual income for Mr. Stinson's level of employment with the federal government is public. And we have printed them off the public military website and shown you that his actual income is $116,000 annually and change, and that a substantial portion of that, I think about $30,000, is actually non-taxable. It's called BAS and BAH, and he gets it regardless of what the child support order says. So we're asking you to declare that he needs to, within 7 days, disclose to the friend of the court his actual income and have the friend of the court recalculate, and that in the interim, he paid child support directly to Ms. Stinson, because once the objections were filed, nothing was taken out of his check. No support has been paid. So even pursuant to the temporary order, an arrearage has been accumulating since the temporary order. So if we could have that arrearage paid in full within 14 days and have him disclose to the friend of the court his actual total income and clarify to the investigator that the BAS and the BAH are non-taxable, so that can be taken into consideration. We need to start a new child support amount at an appropriate level immediately. I am asking the court to backdate it to October 22nd of 2019, not just from the date of the temporary order.
How do I backdate before a motion or request for child support review was done? Isn't that retroactive child support?
You have the discretion under the child support formula to backdate it when circumstances justify. We just have to show justification for its retroactivity. But regardless, I think if we can, maybe Ms. Stinson has right at her fingertips, because she's incredibly organized, the date that she initiated the review, because the guidelines themselves say it should be backdated to then. Do you have that, Ms.
I do. It's October 29th, 2019, and yeah.
Okay.
And I'm willing to look at other authority. I've always operated under the assumption that I can't award it retroactively.
To the date of the petition, that's right in the guidelines.
Right.
That's all we're asking for.
So 10/29/19
Yes.
is a satisfactory
Yes, yes,
start
yes, yes,
date.
yes.
Okay.
Let me just check one other thing, Your Honor, if you don't mind, before we hand the microphone over. I would like to just note for the court that I did not receive an answer to our petition, so I'm going to take the factual allegations in it as admitted.
So I'm looking at your Exhibit 7, which tells me what the BAS rate is. What was this BAH that you were talking about?
The BAH is the larger one.
Basic allowance for housing.
Yeah, it's
I see that. That's Exhibit 6.
Number 6, yes. And that's monthly.
Monthly allowance, 03, that's his rank?
Yes, at least that we last knew.
Okay. All right, Ms. Payne.
Good morning, Your Honor. Couple of things. First, with respect to the filing of a response, we're not required under court rule to file a response. All I received was a notice of hearing. I did not receive any specific objections to the support recommendation. I gathered generally what they were because I saw the support calculation, and I agree that Mr. Stinson's income is incorrect. It does need to be recalculated. We have no problem stipulating to submitting that information to the front of the court within 7 days, as Ms. Hamilton is requesting, and having the front of the court do a new calculation. Totally fine. With respect to a retroactive modification date, the statute 552.603 specifically says that retroactive modification of a post-judgment matter is not permissible except when a petition is filed and then to the date that the petition is noticed to the other party. I believe that was what Ms. Stinson did here, was send in a letter for a statutory review. That's different from a petition to modify child support. So what I ask the court to do is reserve on that issue, and so that when we get the new calculation, we can determine what, if any, retroactive effect that calculation should have. Pending that recalculation, we also agree that child support needs to be paid in some fashion, and will comply with the recommendation and get credit for what Mr. Stinson pays to Ms. Stinson until we have a new support order. I'm saying all this because we are actually, procedurally, we are in the middle of a custody trial with you, Judge. The last time we left off with this case, the court ordered both parties to submit to psychological evaluations, to provide those evaluations to the court so that we'd come back and complete our custody and parenting time trial. We're in the middle of that right now. So this child support piece is kind of bubbling up while the remaining issues have not been resolved with this court. So yes, there should be support paid. Yes, we have no problem submitting all of Mr. Stinson's income information so that there can be a new calculation done. But on the issue of retroactivity, I'm asking that the court reserve on that issue until we see you on the remaining issues in this case, which from our perspective are more pressing. We've been lingering for over a year now in a custody modification, and we're kind of hanging out there, Judge. So, so I partially agree and partially disagree with Ms. Hamilton.
You said trial. It's really an evidentiary hearing, is it not?
Correct.
It's post-judgment.
Yeah, it's post-judgment. You're correct, Judge.
Okay.
It's post-judgment.
May I respond, Your Honor?
Sure.
Yes, okay, so first of all, we emailed and first-class mailed our objections to both Ms. Payne and Mr. Stinson in the spring when these objections were initially filed. And we know that Ms. Payne did get them because when we scheduled the hearing on them, she filed an emergency motion to cancel that hearing because Mr. Stinson couldn't be available. So this is an ongoing problem I've had with that office with, in terms of them claiming they don't get things.
I
that
didn't
they've
file
already
any
discussed.
motions to adjourn this, Judge. I don't know what Ms. Hamilton's talking about.
There is actually an emergency motion that is in the file. We checked on it yesterday. We received it in the mail from her. Mr. Stinson couldn't be here for the originally scheduled hearing pre-COVID.
I didn't.
I'm looking at defendant's first emergency motion to adjourn March 17, 2020 hearing due to defendant's work orders.
Oh, okay.
they-
Sorry, Your Honor. I thought you were talking about something else. That is correct. I did ask to have it adjourned pre-COVID.
So obviously, you did get the motion at some point.
Yes, you are correct, Judge. I retract that statement. You know, it's been a long time since we had this file pending in front of you, so I apologize for any confusion that I caused to the court. You are correct. But we agree, his income is incorrect. It needs to be redone.
Well, that's easy then. Let's get the friend of the court to recalculate based upon all of his income, including the non-taxable portion. If Ms. Hamilton is correct that what is published is in fact what he gets, it should be a pretty easy thing for the friend of the court to do a recalculation, wouldn't it?
Well, what I'm hearing is they didn't make any response to the validity, and there's no argument regarding the fact that Mr. Stinson underreported his income in that respect to the friend of the court months ago, and that there has been a $996 per month order that is a result of the undercalculation that he's paid nothing on since October of 2019. So
No, we are not admitting that we
let's do
underreported
this.
Mr. Stinson's income.
Let's
We
do
submitted
this.
all of his income materials, including his pay printout from DFAS. What the friend of the court did, they did.
I don't need to hear you quibble about that. It's going to be recalculated. It's going to include his taxable income as well as his untaxable income. The effective date, I don't have a problem reserving what that will be. But at some point, I'm going to make a decision on that, whether it's retroactive to the date she made a request. I mean, if it's retroactive to petition, that doesn't make a lot of sense if she didn't file a petition. That, I wouldn't have a date to go with.
Allow me to brief it. She
Yeah,
initiated.
yeah, that's right. Just give me whatever additional you've got on that, and I'm happy to make a ruling on that once I have in front of me the range of my discretion on the start date.
Now, in terms of the ongoing obligation to pay child support, I would note to the court, since Ms. Stinson is desperate for some support, that the friend of the court in the recommended order that it submitted suggested that child support should be effective February 2nd, 2020. That was their initial recommendation at the rate of $996 monthly. I believe, Your Honor, given the level of Mr. Stinson's income, that this court should order him to pay the arrearage that has accumulated pursuant to those terms from February 1st of 2020 to the present forthwith at the rate recommended by the friend of the court, and then we can just settle up once the new support amount has been calculated by the friend of the court based on his real income, she's got to have some child support for this child. She's had him in her full custody since the divorce complaint was filed 4 years ago. So to receive no support since October is extremely burdensome.
She needs to pay what the friend of the court determined forthwith. She shouldn't be left destitute because of pending objections.
Can we get a deadline for that payment in full, Your Honor?
I can give you one. 2 weeks sufficient?
2 weeks is sufficient. What I'd like to do, if it's okay with the court, is I'd like to have Mr. Stinson get that check to my office, and we'll have a direct credit form signed by Mrs. Stinson so that we don't have to wait for the additional processing through the Michigan State Disbursement Unit, since the delay is really not her fault.
I think that's a reasonable request.
Thank you.
That's what I'll order. 14 days from today's date, not from entry of the order.
And it is 14 days from today's date on the payment of all arrearage pursuant to the temporary order since February 1st of 2020 at the rate of $996 per month, correct?
Yes.
Thank you very much, Your Honor.
Okay, and then a recalculation based on total income, reserve the issue of the effective date, so each party has an opportunity to submit argument on that issue. And
One last thing.
yes,
Would the court also order Mr. Stinson to deliver in writing to the friend of the court his actual income, including BAS and BAH, copy me so that we can see that it has been done, say within 7 days?
within 7 days of the order.
That's fine.
Yeah, if I say within 7 days, there won't even be an order entered by then,
That's fine.
because we'll probably be back here arguing about the language of the order.
Yes.
Don't jinx us,
Past,
Judge.
Experience with this file is
Yes, sadly.
That's fine.
so
We
yes.
already stipulated to that, Judge.
Can I make a
Okay,
comment?
very good. Pardon?
Can I make a comment?
Sure.
The number of overnights was also exaggerated. I don't know if that will be taken care of in the new review.
And
It
Ms.
should
Stinson,
be pursuant to
that.
the custody order is how those are calculated. Are you telling
Right.
me that he's not exercising all of his allotted overnights?
No.
The
pursuant to these-
caseworker,
Go ahead.
the caseworker averaged my my stated overnight number and his stated overnight number. So he essentially
Usually they only
exaggerated it.
list his. They usually only list the payer's overnight numbers. Let me look at the order.
No, Your Honor, the guidelines give them both.
Oh, in the guidelines portion? So the order shows him at 105 overnights. You're saying that's inaccurate?
Yeah, it should be 98. That's in my petition.
Yeah, if that's true, that needs to be addressed.
Okay, so I'll put that in the order.
You may.
Thank you very much.
Okay, thank you.
Thank you, Judge.
Good save to my client.
All right, we're gonna try to get this gentleman from the jail. Where is that stuff? Dangler, okay. Weller,
I need the case number.
it is 20-1274. PH.
Okay, Deputy Norrington.
Good morning, this is Judge LaFlamme. Could you bring, victim, okay, Brandon Weller to the phone, please, or to the Zoom room?
How do you spell last name? You said Weller?
Yeah, Weller.
Okay, I will do.
Okay, thank you. We'll be waiting for him.
Okay.
Thanks. You up to a free lunch today?
Hunter, did I understand there was a surgery planned?
Monday, getting a new hip.
Good luck.
Thank you. So looking forward to it. Oh, boy, that was quick. Well, it was turned on, but they still need to bring him into the room.
Can you hear me, Judge?
I can.
Okay, awesome. You're all set? Step out for me, okay?
All right, thank you. Hello.
Okay. Good morning. You are Brandon Weller.
Yes, sir.
Okay. Mr. Weller, you've been accused of violating the PPO that's in place between Danielle Dangler and yourself. You understand that?
Yes, sir.
Okay. I've been given a probable cause information sheet. I'm assuming you haven't been giving it. I'm gonna tell you what it says, okay?
Okay, yeah, this is all new to me. I haven't been to jail in so long, so it's.
All right. Well, we'll try to get this squared away. So I'm looking at a report submitted by, looks like well, I'm trying to figure out what agency Mr. Elston is with. It's
Jackson.
not- Is he a Jackson City police officer?
Yes, and sorry about that, Judge. I didn't mean to cut you off, but now they said I broke my PPO. I never went in her yard, or I was on the.
All right, we'll get to that. We'll
Okay.
get to that.
All right.
So this says on August 19 at 2020 at 502 Gilbert Street,
Yes.
officer says I responded to the area of 210 Gilbert Street, referenced several juveniles fighting at Loomis Park, and one subject possibly had a firearm.
Yes.
Identifies a unknown caller to 911. Upon arrival in the 300 block of Gilbert Street, I observed a light green SUV parked in the 300 block. Weller exited the driver's door. I was not able to gather the vehicle information that Weller was driving. This was captured on Deputy Sawyer's body camera. I was able to confirm in lien that Weller's license is currently suspended.
Yes. Yes, sir.
I was made aware by Officer Caruso that two suspects reference the fight at Loomis Park walked to 502 Gilbert Street, and one of the suspects possibly had a firearm. I was advised that Julian Powell and Kevin Dangler were the two suspects. I observed a van sitting outside of 502 Gilbert Street with Kevin Dangler sitting in the passenger seat. I had Dangler exit the van to speak with me. I patted Dangler for weapons and did not locate any. I was in the process of writing down Dangler's name in my notepad when Weller walked behind me and began to assault Powell. Dangler advised me that he observed Weller punch Powell in the face.
Yes, sir.
Suspect relationship, Powell, Weller, none. Daniel Dangler, Weller, neighbors. Victim name, Julian Anthony Powell. With a date of birth of 2/13/03. Victim interview. Powell advised he wanted to press charges on Weller for assaulting him. Powell advised Weller struck him in the eye with the first punch, and Powell was able to block the other punches by Weller. Powell had slight swelling and redness on his left eye. I was able to collect photographs of the injury. I was able to collect photographs of Powell's injury. Suspect name, Brandon Glenn Weller, born 8/30/87. Suspect interview. No interview conducted. Assault occurred in police presence. Deputy Sawyer and Sergeant Burkhart were able to place Weller in handcuffs behind his back. Suspect injuries, none. Suspect photographs, none. Victim name, Danielle Ann Dangler. Victim interview. During my initial contact with Kevin Dangler at the van, his mother, Danielle Dangler, was standing next to me. Weller began approaching where we were standing, and Danielle advised me she has a PPO on Weller. Weller was approximately 5 feet from Danielle when he assaulted Powell. I was able to confirm in lien that Danielle Dangler has a valid PPO on Weller. The PPO states that Weller is not to approach or confront the petitioner in a public place or on private property. Weapons, personal weapons.
Yes.
Photograph, I collected photographs of Powell's injury. I collected photographs of Deputy Sawyer's broken radio antenna. Body cameras from Deputy Sawyer and Officer Elston. Weller was lodged at JSO. I completed a probable cause form, CCH, and warrant request for Weller. And then he says, please see Deputy Sawyer's supplemental report. And that's just one page.
Okay.
He says on August 19th, 2020, I responded to a fight involving a firearm at Loomis Park in the city of Jackson. While at the park, we discovered the subject in the fight, the subject involved in the fight were potentially at 502 Gilbert Street down the road. At this time, I and Officer Elston responded to the area of Gilbert. We made contact with the subject we later identified as Kevin Dangler, a possible suspect involved with the gun. We were also advised a younger black male with the name of Julian, wearing green jeans, possibly had the firearm. While speaking with Dangler, I observed a black male with green pants come out of 502 Gilbert Street and approach us, identified as Julian Powell. As Powell approached us, I observed a male in a red shirt, identified as Brandon Weller, accosting Powell. As Weller was approaching Powell, I observed Weller to begin striking Powell in the face with a closed hand. I ran to stop Weller from striking Powell. I grabbed a hold of Weller by the upper body and began to pull him off Powell. Weller then pulled away from me and attempted to strike Powell again. I was able to grab Weller a second time and escort him to the ground. Weller stated that he was done and he was able to be taken into custody without further incident.
Yeah.
The antenna on my police radio was snapped off during the struggle with Weller. My body camera did capture this incident and it was tagged in at JSO under county number 138-1524420. So, you're not here for the alleged assault upon Mr. Powell.
Okay.
You are in front of me solely on the issue of your alleged violation of the PPO that Ms. Kevin Dangler has in place.
Okay.
I've got to go through a little script with you. Before I do that, have you been arraigned on the assault charge?
No, I have not yet, sir. I'm just
All right, well, I
I
have
know I
nothing
was-
to do with it.
okay. I just was letting you know. I know I was at fault. I just was out of frustration.
Before you say anything else, let me go through this script.
Okay.
What you're saying is on the record.
Okay.
It's being recorded. You need to be advised of your rights before you say anything at all.
Okay. Thank you.
Okay. I have read to you the actions of which you're being accused of engaging in, that if true could result in you being found in violation of a personal protection order. I need to advise you that you have the right to contest this charge at a contempt hearing. You are entitled to a lawyer's assistance at the contempt hearing because it's certainly possible that a jail sentence could result from the violation. You are entitled to a court-appointed attorney if you want one and are unable to afford one. Do you wish to have the court appoint an attorney to represent you?
I think I want to try to get my own lawyer.
Okay. I am willing to release you on a personal recognizance bond.
He's in jail on multiple charges, so he's not.
I know, Shannon, but I need to do this. Now, that means that you won't be held any longer based upon the PPO violation. However, that release doesn't apply to any other charges that you are facing.
Okay.
If you are able to resolve those charges and get released, my PPO case will not be holding you. So I'm going to allow you to be released on the PPO violation without a bond.
Thank you.
In other words, a personal recognizance bond. But that's not going to get you out of jail today because you're being held on some other matters as well.
Okay, and now what else are they holding me on?
What does it show, Shannon?
A lot.
My clerk
I just figured you'd
just
want to know.
looked it up on the screen and she just says a lot. My guess is, at a minimum, you're being held on the assault on Mr. Powell that occurred in the presence of the police.
Yes. Now, do they understand the whole story like that's going on like before everything even happened? I know I'm not justifying what I did at all. I don't want to justify nothing that I did. But it's just been an ongoing problem for years, and that our house has been shot up. Their house has been shot up. It's like it's an ongoing problem that I just want to get resolved. Like
I understand that, sir, but that matter is not in front of me.
okay,
The only reason you're in front of me is for an alleged violation of the PPO.
okay,
And the PPO, the specific one, I mean, it was within the report, was that you were in the presence of Danielle Dangler, apparently within 5 feet of her, when this went down, and the PPO prohibits you from being in her presence.
Gotcha.
Okay, so here's what I'm going to do. I am going to schedule this matter for a hearing on the PPO violation. It's going to be a little while before that happens because I'm going to be gone a couple of weeks. It sounds like there are other issues that are more serious that you're going to have to deal with, wholly apart from a PPO violation. And that's not up to me. That's up to whatever judge is presiding over the assault charge.
Wow.
And you should be arraigned on that. When were you arrested?
I was arrested yesterday.
Okay, well, you should be arraigned on that. I would expect later today, but I really don't know anything about that. All I can do is deal with this particular situation. So,
Okay, I just want to
you-
try to get it figured out. I got 7 kids at home and I made a mistake that just out of frustration, man.
All right, well, like I said, I can't deal with that. I can only deal with the PPO violation. I'll make sure you're not being held for that, so that if you do get released by whatever judge arraigns you today or whenever you get arraigned, that this won't be an obstacle to your release. You will be notified of a hearing date for the PPO violation. My guess it's not going to be for at least 3 weeks at the earliest.
Okay, I appreciate you. Thanks a lot.
Okay, you're welcome. That concludes our hearing, sir.
Okay, now do I just, now you said I don't got no bond, so I know the court's closed tomorrow, so how do they sit me in here till Monday or?
I don't know, whichever judge was assigned your case will need to conduct a hearing. We have been conducting arraignments other than on scheduled court times. There's no way I can tell you when it's gonna happen. I don't
Now, they
have
didn't
any
charge
control
me with
over-
any felonies or anything, did they? I don't have any
I don't
felonies.
know. I don't know what they charged you with, sir. I don't have that in front of me.
Okay, because
I just know you gotta-
I'm just confused because I never was told what I got charged with. So I'm down here not even really knowing, like, because all I did, I
Based on
violated
this-
my PPO and then, I assaulted them. Other than that, I didn't do, I owe tickets.
It's the assault that's your bigger problem, sir.
Okay, thank you.
And that's not in front of me.
All right.
All
I
right,
appreciate
that
it.
concludes our hearing.
All right, thanks.
You're welcome.